Part of the group that wrote the whole movie for the 21st century. Yeah. Team bitches. I sat in on the panel yesterday. I knew you were going to ask me that. It just escaped me. I'll figure it out. No, Bob Bash used to I teach Randall's was where I got addicted to thinking the Federalism.
We have an agile.
I was hanging out in Prague just a few days ago. We see each other at a couple of different opportunities. Yeah, it's great. Yeah, I told him when I was retired, I wanted to do Yeah, I couldn't find any
We should have it.
The other one's the other we also have a joint use system. Yeah.
You're good to go. Thanks, guys. Ready?
Welcome everybody to the West Virginia Law Review Symposium. So once everybody gets their food, if you can have a seat and get settled in, for the next day and a half, we have some really exciting things for you. Students, any students who are here that are meeting class requirements, except my students, sign in at the sign-in sheet as you come in at the CLE desk. Restrooms are out the door and to your left. Please either turn your cell phone off or put it to vibrate. And the sessions, other than the lunches, will be in the Luger courtroom, which is to your left again, and then left down to the end of the hall. But I'm sure everybody will be able to find it. Well, I'm really excited about the lineup that we have for this conference on home rule, and I can't think of a much better way to kick it off than our lunch speaker for today, Paul Diller. Paul is a professor at Willamette Law School in Oregon, and he has written a good number of law review articles recently on preemption and home rule and Dillon's rule and those topics. He's also part of a group of professors who has put together a document called Home Rule for the 21st Century, which proposes a constitutional amendment for states to adopt to give local governments more home rule authority. And today, Professor Diller is going to talk about home rule and lobbying and the ability of local governments to lobby their state officials. So please join me in welcoming Professor Diller.
Good afternoon. Thank you. It's great to be here. I was mentioning earlier that I was speaking on home rule and realized that everyone here is speaking on home rule. I'm used to being the only person talking about home rule at most conferences I go to, so it's great to be in good company. I'm going to talk about cities' ability to lobby their state legislatures primarily, and how and why that should inform home rule, but I'm going to start with a bit of background first before I dive into that. So, cities are creatures of the state, we have been told, at least since Judge John Dillon, in the aforementioned Dillon's Rule, so dictated in his 1872 treatise on the law of municipal corporations that is still cited by many jurisdictions to this day. The Supreme Court, as many of us in this room know, affirmed Dillon's view of local inferiority to state supremacy in its 1907 holding, Hunter versus City of Pittsburgh, in which it allowed Pittsburgh, pursuant to a state law passed by the state legislature, to swallow the city of Allegheny, the former city of Allegheny, despite the opposition of the residents of Allegheny to that annexation. So at least as a matter of federal constitutional law, cities are essentially powerless, conceived as convenient agents, as the Supreme Court put it in Hunter, of the state, that the state may abolish or rearrange at its will. Of course, most of us here know that Hunter was not the last word, either regarding federal constitutional law, nor regarding states' legal powers. Of course, since Hunter, the Supreme Court has said that there are some limits, not many, but some, on states' ability to restructure their local governments, most prominently in the well-known case of Gamillion versus Lightfoot out of Alabama in 1960, where the Supreme Court said that it violated the 14th or 15th Amendments, depends on which opinion you read, for the state to restructure Tuskegee, Alabama, so as to exclude almost all of its black residents. And then, even putting aside federal Supreme Court jurisprudence, while Dillon's rule may have sort of become the prominent view as a matter of state common law, a movement began in the late 19th century to establish what we now call home rule in several states. This movement eventually became successful in a majority of states who had established some sort of default lawmaking authority for their cities, and many states eventually adopted home rule for counties. That's been a little less successful, a little less prevalent, but it depends on the state. There are some states where county home rule is quite well established. For most of my talk, I'll refer just to cities, but a lot of what I say would apply to counties as well, particularly in jurisdictions with county home rule. Now, early versions of home rule often provided some kind of immunity function or a shield from state interference. This was in the Constitution, enforced by courts, whose enforcement was respected by political actors. And the idea was that for certain local matters, certain matters denominated local by the state constitution, the state either could not interfere or would have to overcome a higher bar of review to interfere. This was more common for matters like local employment or the inner workings of local government. Perhaps matters mentioned in the city charter, like how many city councilors a city has or how it organizes the internal workings of its municipal government. As time went on, as we moved out of the late 19th century, early into the early and mid 20th century, fewer constitutional home rule or imperio home rule regimes, that is, states with a home rule with some kind of immunity or shield function, remained. At the current moment, a handful of states have some kind of prominent version of that immunity function in their home rule. Colorado and California are two of the most well-known examples in that they have explicit state constitutional protection enforced by the judiciary for certain matters like how a jurisdiction handles treats its local employees, how it pays them, how it hires them, how it fires them. Some of those matters are explicitly protected by those state constitutions, as well as a handful of others. Most states with home rule, however, at least since the middle part of the 20th century, have effectively moved towards some version of legislative home rule. It's a term that most of you are probably familiar with. And the idea behind legislative home rule is that all legislative authority is deemed delegated to cities unless and until the state preempts that authority. So a city gets essentially all powers that aren't preempted. This is the model that was proposed by the American Municipal Association in the 1950s. That organization later became the National League of Cities. In a couple of model constitutional provisions it promulgated in the 1950s and 1960s, and it became fairly widespread in its adoption and fairly successful. It succeeded at delegating a wide array of powers to local governments without them having to kind of come to the state legislature to ask for power. But it also left cities vulnerable to state preemption. And we've seen a lot of that in the last several years, as I'll discuss. So while there are vestiges of imperial home rule in California, Colorado, or maybe a little piece of local government is protected by the judiciary in some other states, most states are essentially legislative home rule states these days. Most states, that is, with home rule. There are about 5 or 10 who don't have it. Depends on how you count. I've never seen. There's not a lot of there's a lot of disagreement on exactly how you count home rule states, but most would say probably about 40 states are home rule and 5 to 10 are not. But operating within this framework of legislative home rule, we've seen a rash of preemption occur in the last decade. often taking on a particular political tone, resulting from a particular political dynamic in some states where you have, after especially 2010, you have Republican-led state houses and governors, and often cities that lean in the opposite direction politically and lean more Democratic. You see this dynamic in states like most prominently Florida, North Carolina, Ohio, Wisconsin, Michigan, Texas, to some extent Arizona, and then to a lesser extent in Indiana, Tennessee, Virginia, and Arkansas. And so in many of these states, you've seen preemption of a wide array of areas. You see what are called Deathstar Bills. I like that name as a Star Wars fan. These bills strip local governments of all authority to regulate labor and employment. These bills often come in response to efforts by cities, successful or not, or murmurs of efforts to establish things like higher minimum wages, local paid sick leave ordinances, paid family leave, and in some instances, anti-discrimination ordinances, or extending their anti-discrimination ordinances in employment or public accommodations to go beyond what state law protects. They're not always Death Star bills. Sometimes the efforts have been more targeted, like in Arkansas, for instance, where the state preempted local authority just in the anti-discrimination realm, or in North Carolina, where we had House Bill 2 from the state legislature in 2016 that was in response, or seen as a response, to Charlotte's and non-discrimination ordinance regarding public accommodations. So the state legislative proposal became known as the bathroom bill because it was seen as prohibiting cities from allowing folks to use the bathroom of their choice. Although actually that had a broader sweep in terms of what it preempted, the bill from the state legislature. You also see preemption of cities' ability to regulate discrimination in housing on the basis of source of income, which is really an effort by cities to allow folks using Section 8 or housing choice vouchers to rent. Some cities and some states have tried to ban discrimination on that basis, but some states have said to their cities, no, you may not. Texas did that, and now there's litigation involving Dallas's ability to implement that kind of ordinance on its own. You see battles, preemption involving inclusionary zoning, with some state legislatures saying that's not a tactic that the city will be allowed to use. Outside of the employment or discrimination realm, you've seen in several of the states I mentioned earlier, plastic bag bans. That is, not letting local governments ban plastic bags, or not letting local governments require a charge of 5 cents or 10 cents for plastic bags. You also have seen prohibitions on local hire laws or municipal residency requirements for municipal employees. Wisconsin and Ohio in particular, you saw prominent battles play out over this in the last decade or so, where the state legislature said to the cities, you may not require police officers to live within the city. And here you have the kind of interesting political dynamic of public employee unions teaming up with often Republican delegations in the state legislature to target the city's practices. We've also seen sanctuary city bans, prohibitions on local efforts to expand voting eligibility, state preemption of local authority to regulate health and nutrition, like in the realm of menu labeling, cigarette regulation, or environmental tobacco smoke ordinances. A lot of preemption of gun safety measures that cities might want to adopt. Now, a lot of that goes back a long way, actually. Many of those were adopted in the 80s or 90s. Those aren't as recent as some of these other efforts, although some of the enforcement mechanisms have been ramped up, as I'll discuss soon. And then in Virginia, we have again, a statute that goes back a long way that preempts, but where the enforcement has become more prominent, and that is requiring cities or counties to retain statues of Confederate soldiers or Confederate monuments, what my friend Rich Schrager at UVA calls the statute. And so in many of these states, it's not just the wide scope of preemption that has drawn notice and from some quarters concerns, but also the methods of enforcement. You've seen increasingly in states like Arizona and Texas and Florida efforts to either create or use what some folks call punitive preemption. That is saying to a city, okay, not only can you not enforce this ordinance that has been preempted, but if you attempt to, or if you even pass it, you will lose state funding. Or you, a local official who votes for this, will be kicked out of your office, or you may even go to prison. And so we've seen in Florida an effort to enforce a state law that threatens to imprison local officials who vote for gun safety regulations. So this entire new landscape has been called by some folks, like Richard Brafalt at Columbia, the new preemption. It's not your grandfather's preemption anymore of just, the state overturning a local law here and there, but rather the wide scope and the strong enforcement mechanisms. Others have called it hyper preemption or super preemption. But it's not just limited to sort of red state legislatures and big blue cities in those states. You see the dynamic playing out in different ways in other political environments. In states like California, Oregon, and Washington, you see tension between the state legislature and state laws and local authority to regulate local employees. You've had cities sue in California regarding the state law that requires minimum wages or prevailing contractor wages for local employees or local contractors. There have been disputes going back several decades about unionization of local employees and local public employees. Immigration has played out in a different way in states like Oregon and California, where there are several county officials, county sheriffs who want to cooperate with ICE, Immigration and Customs Enforcement, the federal agency, and the state says, we won't let you. And so you have that dynamic flipped in those states. And similarly, in the context of gun regulations, with Virginia now, the changes in the state legislature, and last I saw it failed, but there were efforts to increase regulations of certain kinds of firearms. There was a lot of talk by certain county officials of calling their counties or creating Second Amendment sanctuaries that would be immune to those state laws and their enforcement. And many other issues where we see preemption in effect, and we see significant tension between states and localities scramble any red-blue divide. It's issues like soda taxes, where in Oregon and California, the state legislatures, dominated by Democrats, nonetheless recently preempted the ability of local governments to impose taxes on soda or sugar-sweetened beverages, SSB taxes, as they're often called. Land use, you see in a state like Oregon, where I come from, significant efforts to promote affordable housing by the state legislature by, for instance, essentially abolishing single-family zoning, by requiring that all cities allow up to quadplexes in areas that they have zoned single-family. And some of the cities that object to that, are cities that voted for some of the legislatures who voted for that bill. And you see a similar dynamic in California, where the state legislature, as I understand it, hasn't successfully passed anything similar, but is considering passing laws that would upzone areas around public transit. And a lot of the opposition comes from communities who otherwise might support much of what the state legislature is doing. You continue to see battles over other revenue sources between states and local governments, and unfunded mandates, as always, remain a source of state-local friction. Now, if things really are different in this age of the new preemption or super preemption, of hyper preemption, then perhaps it is time to reconsider home rule, and in particular legislative home rule. And so, as Professor Richardson mentioned in his kind introduction, I have been working with several other local government scholars on a potential new proposal for home rule for the 21st century. And it contains a lot of different elements. I'm happy to talk about that more in the Q&A if any of you are curious. And I'm happy to send you a copy if you'd like a copy, or tell you where you can find it. But one of the issues that we spent a lot of time talking about, and that I'm still thinking through, and I think any state that might adopt some version of this would need to think through carefully, is whether it is time to turn back the clock, so to speak, and move back to a version of judicially enforced protections on local authority, to return to a version of imperio home rule. Some folks say, what good is home rule if there's no constitutional protection for local decisions? And perhaps given the focus and attention paid to judicial review at the federal level, and the renewed role, robust role that the U.S. Supreme Court has played at policing federal state boundaries under the 10th Amendment and the Commerce Clause, like in cases like Lopez, Morrison, or Sebelius, there is a temptation among some to reinstitute a similar approach to the state-local divide. But there's a lot we need to think about before we do that, and so that's what I want to talk about with respect to lobbying. Now, just to put my cards on the table, I'm a bit of a skeptic about judicial review. I think I'm a little more skeptical than many of the folks I work with in the local government law community. Another process that we considered when we talked about home rule for the 21st century was some kind of procedural protection for local authority, like requiring, say, a supermajority to preempt local ordinances or to strip power from local entities. That's my impression of how Illinois works in some realms. Now, for this to work, for a procedural protection as opposed to a judicially enforced substantive protection to work, to some extent you have to have confidence in your legislature, and the public needs to believe that its legislature is fairly constituted. In many of the states that have seen some of the most dynamic, some of the most robust, some of the most punitive preemption since 2010 and a little bit since 2000, you have high or strong evidence of political gerrymandering of those legislatures. And so in states like Ohio, Michigan, Wisconsin, North Carolina, Florida, there's very good evidence that the state legislature after 2010 districted in such a way as to give one political party extra power. And so when you think about a procedural protection, in a highly gerrymandered legislature, it still only may work so well because you have a legislature that is already skewed in a particular direction that may cut against urban authority. But nonetheless, procedural protection for home rule, say requiring 60% vote in the legislature to preempt local law or to strip authority in a certain area, would provide more protection than a mere 50% plus one. But if we're going to go in a more substantive direction, move toward the judiciary, I think it makes sense to think about the extent to which local governments can and cannot protect their interests in the rough and tumble of the legislative process. Just a little caveat or footnote, I guess. I'll mostly focus on the legislative process. There are other ways home preemption can happen, such as by administrative rule, so out of the administrative process, or by initiative in the 15 to 20 states that have it. That raises all sorts of other issues I won't get into in detail. But you can have preemption by initiative as opposed to preemption by the legislature. But focusing on the legislature, thinking about this issue brings to mind Herbert Wexler's famous 1954 article, The Political Safeguards of Federalism, that I'm sure many of you are familiar with. If you read it again, you'll notice it's very dated because it's before one person, one vote. It's before we had the Voting Rights Act. So, in terms of who could actually vote in many states in the South, it was, a very different world. But nonetheless, Wexler famously argued, and with some success, that states could protect themselves from undue federal encroachment through the normal political process, i.e. the legislative process. I won't get into the details of Wexler's article, but it was extremely influential. It arguably drove 30 years of the Supreme Court's jurisprudence on federal-state relations, and still is often cited to this day by his former student, Ruth Bader Ginsburg, usually in dissents when she's dissenting against the majority, saying that yes, there is some protection for states in this particular instance. But nonetheless, it still remains a very influential way of thinking about this kind of issues. So if we sort of move that down to the state local level, what might we think about? Well, cities and counties obviously do play a role in the legislative process. They have ways to protect their interests. Local officials routinely endorse or not people who run for state legislative office and statewide office. And so that's a way in which they can make their views known, both in terms of whom they choose to endorse and whether they endorse the next time after certain votes are taken. Local governments and local officials also lobby. They do this by coming out in favor of or in opposition to proposed legislation, by contacting their state representatives or senators, perhaps the very ones they endorsed or didn't, about legislation that may affect the cities they represent. They often testify in front of state legislative committees. Local officials can also speak publicly about state issues or proposals at the state level by writing opinion pieces or otherwise communicating with their constituents, the very constituents who also vote for state representatives and state senators or state assemblymen, whatever your state calls it. Local governments also, of course, hire paid lobbyists, which is something we tend to forget. This is very common. Around the country, local governments spend millions of dollars annually to lobby state legislators. Usually it's the larger cities who have more of a lobbying presence because they have a larger budget. But even smaller cities, if it is worth their while, will sometimes hire a contract lobbyist for a particular issue. And then, of course, local governments, whether cities or counties, team up to lobby en masse. Every state has a municipal league or a league of cities, and same thing with counties or school boards or special districts. Every state has its group, lobbying group of those who represent the interests of that particular form of local government in the state legislative process. These entities are often some of the most well-known lobbyists in the state house, but sometimes there is disagreement among their constituent members. Sometimes cities don't necessarily agree among themselves on which positions to take as a whole vis-a-vis proposed state laws. Nonetheless, this can be a tool for lobbying against preemption in the state house. Of course, despite all of these tools, what cities can't do, unlike some other interest groups who may be pushing for preemption, is contribute to campaigns. So if you think that actually matters in terms of the legislative output it produces, which political scientists still disagree on to this day. I know for many of us it seems obvious, but there is still a lot of dispute in the political science literature on that question. But if you think campaign contributions do affect outcomes, cities can contribute in the way that, say, Coca-Cola can, at least in my state, which allows, in Oregon, corporations and unions can give directly to campaigns. Okay, in other states, only individuals can, but they may be, the CEO of Coca-Cola or what have you, or they set up PACs. But so that's one thing that cities can't do. Of course, local officials can, but they probably don't have quite the resources that the CEO of, Coca-Cola does to make a campaign contribution. Nonetheless, without that particular tool, lobbyists are still important for the functions they serve at communicating with, educating, and even pressuring legislators, and they are a tool that cities happily and routinely employ. So what does the academic literature, mainly in political science, tell us about cities' ability to protect themselves through lobbying? There's not much out there. There's a lot more literature that focuses on the federal level. But here's what I was able to come across. And if I cite somebody, I'm sorry, I don't have a PowerPoint. If you're curious and you want to hear the name or know the study, just ask me afterwards. One study by Gerald Gamm, a political scientist, and some other authors, finds that the unity of local delegations is key. So if a delegation from, San Francisco is split in the state legislature, then San Francisco is less likely to get what they're seeking from the California legislature. But if they're unified, they're much more likely to be successful. And Gamm and his co-authors looked at hundreds of bills going back several decades affecting big cities and found that this was extremely important. Interestingly, they found that Reynolds versus Sims, the famous 1964 case that ushered in one person, one vote around the nation. Some states already had one person, one vote by their own state constitutions, but many didn't. That he found that actually hurt cities in the legislative process because it created larger delegations that were more likely to split. It's interesting. I'm not sure most cities would say, oh, let's go back to having less than one person, one vote. But nonetheless, he finds that was kind of an unintended consequence of Reynolds versus Sims. So the importance of unity brings to mind some interesting implications. It's a reminder of the importance of districting, which I'll say a little bit more about later. But perhaps having representatives or senators who represent just a sliver of a city, like say a sliver of Charlotte, makes it easier for the North Carolina legislature to vote for something like HB2 that targets Charlotte than if the entire Charlotte delegation were opposed. Other findings of the literature are that lobbying may lead to more money from the state. The research is somewhat mixed on this. One study by Dr. Payson of NYU demonstrates that among California cities, those with more resources, e.g. Their own source revenue, they get more from the state if they spend more on lobbying, whereas those who have less resources get less. And so she finds that lobbying can actually reinforce pre-existing inequalities among cities, which sometimes states try to actually smooth out through their revenue distribution or resource distribution schemes. And so that lobbying can lead to more money. There's some other data, some other studies out there that question that. So the data on lobbying's effect on state aid appears to be somewhat mixed. Unfortunately, I was unable to find any significant empirical research on how effective cities are at lobbying en masse through their municipal leagues or leagues of cities. Maybe that's hard to control for, but I wasn't able to find any studies showing just how effective those are when they come out in support of a bill, when they come out to oppose a bill. How effective are they empirically? Couldn't find any data on that. There were some anecdotal survey evidence showing that municipal league lobbyists are well liked by legislators and considered well informed and believed to offer valuable information to legislators. But no clear study indicating their track record of success. So we know some things about cities' ability to to lobby. They're not helpless creatures in the legislative process. They are active, present forces in state houses. Whether this is enough of a legislative presence or enough lobbying strength that we think judicial protection is not required is difficult to say. But clearly cities have some protection in the legislative process through normal political means, minus the campaign contribution issue, but plus endorsements, which usually corporations or just individuals don't make endorsements. Unions do, but corporations don't usually expressly endorse a political candidate. Of course, lobbying and endorsements are not the only ways that cities can protect themselves from state preemption and infringements by the state that they dislike. My aforementioned friend Richard Schrager of University of Virginia has demonstrated that cities can sometimes turn to corporations and to other non-governmental organizations to exert pressure on state legislators to change laws. You saw this in reaction to North Carolina's bathroom bill, where the NCAA and several organizations and corporations agreed or threatened to boycott North Carolina until that law was changed. Now, I think those kinds of tactics are likely to be effective only with kind of hot-button social issues, and not with respect to more bread-and-butter fiscal issues that cities may have concerns about. But nonetheless, they are a tool outside of the normal sort of legislative process that cities can use to try to resist preemption by the state. So, final thoughts. If we think cities lobbying is a good thing, or we just recognize that it happens, and we think that taking that into account should help our determination of the appropriate state and local balance in our legal system, in our home rule system, we need to also think then about how fixing state democracy, rather than just the vertical state and local distribution of power, is another important part of the solution to the new preemption or hyper preemption, if we see that as a problem. And so two reforms come to mind in particular. One is districting reform, reducing the polarities of red-blue or blue-red splits in legislatures, which are often exacerbated by gerrymandering, may help create a legislative process in which cities have a fairer shot at getting their priorities heard. Perhaps respecting local boundaries in districting, which is something many states say they do, but not all actually do it, might lead to more unified delegations in the State House, because you're less likely to have folks representing just a sliver of this city or a sliver of that city, rather their entire jurisdiction would be in that city. That may cause other problems I won't get into now, in terms of unintentional gerrymandering, which is a dynamic that several political scientists have studied lately, namely Jonathan Rodden of Stanford has shown how concentrating legislators in particular cities can actually lead to certain political parties getting hurt overall. But putting that aside, it may nonetheless pay this dividend of leading to more unified jurisdictions in state legislatures who may be more effective at resisting preemption or targeted action that strips local governments of power. And then, of course, the other proposal that is a little bit difficult at the moment due to current Supreme Court jurisprudence, but is nonetheless something we shouldn't forget about, is campaign finance reform. Insofar as cities are good lobbyists but do lack that additional tool of campaign contributions, if we think that's an important tool, then we need to think about how the state legislature and the state lawmaking process is set up to facilitate that tool or not. And so if cities are playing with sort of one hand tied behind their back as compared to corporations or unions, as they are in Oregon, for instance, where corporations and unions can directly give to campaigns, then changing those laws may play a role in increasing cities' abilities to represent themselves in the legislative process. So, enhanced judicial review of preemption is one option, but so is systematic reform to state democracy with respect to fighting back or trying to deal with this new preemption or hyper preemption phenomenon we're seeing around the country. Nobody would argue that all preemption is bad, that every instance of preemption is bad. The question in many ways is rather about how that preemption is produced. What is the process that produces that preemption? Does it result from a process in which cities had a fair chance to be heard? Do we think it comes out of a legislature that fairly represents the statewide voting public? Do some interest groups have an outsized role in that process due to campaign contributions? These are all questions that I would urge reformers in any state to be asking as we move forward with potentially ushering in a new era of home rule. The answers may vary by state due to their the populations of their cities, the potential geopolitical split in their voting public, but they're important questions to ask and attempt to answer as we move forward. Thank you very much. I'll reserve some time for questions. Would love to hear your feedback.
Check. Okay, so if anybody has a question. Sorry, I should have worn different shoes.
Okay, so you said that, thank you for coming and speaking today, by the way, going over it very well in Professor Richardson's class in land use. But when it comes to the different types of protections that you were talking about, do you find that there are certain laws that would be better benefited by having the supermajority protection in legislatures rather than judicial review? And if so, what would be some of those distinctions that would make them better for that type of protection?
It's a good question. I haven't thought about that. I mean, yeah, I can imagine a system where we require a supermajority in the legislature for certain things, but then judicial review under a compelling or substantial state interest for other things. The reason I'm a little concerned about judicial review is because it depends on who's on the courts. You know, most courts, 37 out of 50 states elect their Supreme Courts. So to the extent that state-local battles have become this really nasty political fight, I'm a little worried about transferring that also over to the judicial realm and making that another issue to be fought about in judicial elections. I know I'm in a state where judicial elections have been very hard fought, and there's been some controversies about them here and elsewhere. I'd say, where you do see the most well-established judicial protection for local government currently, both in California, Colorado, and in some other states, is regarding the structure of local government. Like how a city chooses to set up its city council, whether it's by district or at large, whether it has term limits for its mayors. Those kinds of decisions are usually seen as not really having significant externalities. So why should anybody care in Wheeling, West Virginia, if Morgantown elects its councilors by district as opposed to at large? That's the thinking there. Would the judiciary be better at enforcing that kind of thinking than the state legislature? Maybe, insofar as it's kind of more of a neutral principle rather than a political decision. But not something I've thought about in a lot of detail, but that's a good question, whether to sort of slice and dice the review. Do we need the mic? Or, oh, no.
Thank you again. That's such an interesting presentation. I heard you say that sort of not all preemption is bad.
Uh-huh.
And I'm wondering if there are certain fields of law or areas where you think that state preemption is in fact particularly useful or appropriate.
Well, I'd say the area where, at least among law professors, and we're just one entity, but at least among our demographic, there's widespread agreement that preemption might be good is land use, specifically with respect to housing and as a means for fighting exclusionary zoning. And so one of the critiques, frankly, of our proposal is that it doesn't do enough in that regard, of the National League of Cities proposal, is that it doesn't do enough to fight cities' propensity to zone only for single family and zone out more affordable housing. And that's just a classic collective action problem. Any one city says, well, let's put the poor people over there. Why do we want to bring in housing that's going to just increase our costs for social services and schools if the city pays for schools, which it does in some states and doesn't in others. But so that's one area where I'd say there's a lot of agreement that more preemption might at least help solve that problem, if we agree that's a problem, exclusionary zoning.
I can expand on that a little bit. I live in Bluefield, and we recently had a zoning issue with respect to a group residential home for people who have completed opiate treatment. So a lot of people in the community were opposed to that, but fortunately, I was asked to opine on it as the city attorney, and fortunately, we have a state preemption in that regard. So we have, the state provides that group residential homes and group residential facilities shall be permitted uses in all zones or districts. So, I mean, that solved the problem for the city, and it's definitely a need, but so in cases like that, it can be extremely helpful. And there's a similar state preemption in West Virginia for domestic violence shelters as well.
Okay, thank you.
Excuse me.
Yes, the question I'd like to mention has been in the news a lot lately. It has to do with city versus state budgetary decisions. I've read in the news in a lot of cases, basically cities have been giving tax breaks to large corporations to come into their cities. But then at the same time, what will happen is a lot of cities will run into financial trouble due to pension obligations, budgetary overruns and everything. So I'm curious about the relationship between who gets to make the final call on budgetary making between cities and the states. If the states know that the cities could be coming to them for emergency funding, does that mean that the states have any right to interfere in the city's budgetary decisions, and what sort of solutions have been tried for that?
Yeah, that's a great question. One which could require a very complicated answer. I'm not even sure I'm capable of answering it entirely, but let me give you a few thoughts. One is the fiscal realm, taxes, borrowing. That's an area where there has been a lot of preemption of local authority going back several decades, particularly in states that have the initiative process. So California, for instance, famously passed Proposition 13 in 1978, which really hamstrung the ability of local governments to raise revenue. Oregon has similar measures that were adopted, a little bit different, but basically similar idea, adopted in the 1990s, that severely limit the local government's authority to raise revenue by property tax. Sales taxes, income taxes, sometimes those are regulated by the state constitution significantly or by state law. So I guess in response to your question, we're already dealing with a system where local choices are highly circumscribed. Now, maybe that's an issue we need to look at reforming, and that's one of the things we talk about in Home Rule for the 21st century, is relaxing some of that preemption so cities can have more of a choice in terms of the kind of revenue mix they would like to use to provide the services they think are appropriate for their community. What you're suggesting is there may be some abuse of that, or some concern about kind of a race to the bottom. With cities chasing Amazon or whatever, and giving away the farm to get Amazon. And I'd say where that's a significant dynamic, I would go back to this idea that not all preemption is bad. I mean, if there is a race to the bottom, a collective action problem that maybe the state needs to worry about, that's a case where preemption might be appropriate.
I think we have time for one more, if it's a quick one. Does anybody have one other question?
Thank you. For example, in Virginia, where we see state legislatures flip, I know it doesn't happen very often. Do we see a desire by the legislature to then turn control back over to the cities, or is there the fear that now more say, Republican-leaning cities will now try to enact these Second Amendment sanctuaries, or do they finally get into power and say, okay, no cities, we're going to hold on to that?
So Virginia's an interesting example, and no one called me out on it, but I wonder if some of you were thinking I mentioned Virginia, but Virginia is actually Dillon's rule state. It's probably the most famous one because it's the most populous. And so, I mean, technically Virginia is Dillon's rule, meaning it's never delegated all default legislative authority to its cities. But it has a ton of piecemeal delegations of power to its cities. So, you know, how functionally different is it from a home rule state? I'm not sure. I'm not an expert on that. But it is a Dillon's rule state. There is some talk, I hear in Virginia, of changing that, of finally adopting home rule. And some of that may be because it's maybe some of the bigger cities that want it, and they're perhaps better represented in the new legislature. And Virginia, of course, is also different from a lot of states in that the big cities aren't actually within counties; they're separate entities. So Richmond is not in a county, and Arlington is not in a county. As far as you know, restoring power. So if they do adopt home rule and repeal Dillon's rule, that would be kind of an across-the-board empowerment of local governments. Would it apply to counties or just cities, and would it, you know, promote something like Second Amendment sanctuary? Probably not. If the gun safety laws we're talking about are supposed to apply across the board, but it would at least give this default authority that would apply to every single city in the state, regardless of the political preferences of those residents. I do think there is also talk I've heard from Virginia of repealing some of the specific impositions on localities, like the statutes. I've heard that may get repealed. So then, you know, Charlottesville can choose to take down its statue of generally, and other cities probably will, or some cities may choose not to take down their statues. Thank you.
Thanks again to Professor Diller. That is the conclusion of the lunch period today. So if you want more food, it's still in the back, and you can grab that. We have about 15 minutes, and we'll begin in the Lugar courtroom, which again is out of the event hall to your left, and then there's a sign pointing down the hallway. So thank you all.